Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines. We're pleased to have on the show Jill Kraft. She is an attorney who specializes in discrimination litigation. She's going to talk about the purpose of the laws, and that was basically to protect folks who the legislature decides needs protection, and what you have to do to file a claim for discrimination. So join us on the next Legal Lines with Jill Kraft.
Want to learn the secret to big savings on TV, internet, and phone? It's bundling your services with Cox. When you bundle with Cox, you get digital cable, high-speed internet with Power Boost, and telephone, all for one low monthly price. That's 3 fantastic services at one low price that will make you smile. The secret is out. The more you bundle, the more you save. So get a whole lot and save a whole lot when you bundle with Cox.
Welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show today Attorney Jill Kraft. Jill is a specializing attorney in discrimination. Jill, thank you so much
Thank you for having me.
Coming on the show.
Thank you.
Tell the folks a little bit about yourself.
Well, I'm kind of from everywhere, I guess is the best way to say it. I was born in Indiana in the Midwest. I grew up in Connecticut, went back to college at Indiana University, graduated with 2 majors, one an honors degree in economics, and ended up at LSU Law School and stayed. So
Wow.
I've kind of been everywhere.
That's great. Tell the folks how you got into this area of expertise.
Actually, when I came to LSU, I thought that what I was going to study was international law because it's the only law school in the country that has kind of a dual curriculum.
Really?
Absolutely. I wrote my master's thesis in college in economics on the International Monetary Fund and the World Bank and was really, really interested in it. Once I got here, I fell in love with the people, I fell in love with the culture, got married, had 3 children
Love
at
the
that
South,
time.
huh?
Love the South.
Me too.
Love the warmth, and I hate to shovel snow. And really kind of fell into employment law at the perfect time. In 1991, when I started practicing law, all of the federal statutes had changed. They now allowed victims of discrimination to recover damages where they could not before.
It was just remedial type of steps the employer had to take?
Right. It was primarily either put them back to work or pay them back pay and front pay and things of that nature.
So no big bucks involved at all, usually.
Right, but it left, I think, the victims fairly uncompensated for what they had lived through. And then Congress in 1991 also revamped the civil rights statutes and added some new things, revised the Voting Act's legislation, which led us to the current state of that particular statute. And then, of course, on the heels of that, in 1992, we had the advent of the Americans with Disabilities Act. And the way that I guess I kind of fell into it is I started my own law firm in 1992 or thereabouts, 1993, and the first person referred to my office was a gentleman who told me he had been fired because he had cancer. And at that time, I didn't have a whole lot of familiarity with the laws, and I remember telling him at that time, I'm not sure if it's against the law, but it really sounds terrible to me.
Pretty much motivated.
Absolutely.
You, didn't it?
And then, of course, from that case, I think it was the first Americans with Disabilities Act case filed in the state, probably, in a couple of states. And then the next person who came in was a victim of sexual harassment. And at that point in time in the laws, things had kind of evolved to the point where we traditionally think of notions of things called sexually hostile working environments and all that kind of stuff. So I've been extremely blessed and very fortunate to have fallen into a niche that I absolutely love.
Well, you're no doubt an expert in it. In fact, as I was preparing for this, read that you have received or obtained the largest monetary awards in the state of Louisiana, and you travel all over the nation to litigate this.
I do. I've been really fortunate, and I think it's driven by the fact that my clients are really, truly wonderful people. If you go in my office, for example, there's not a piece of artwork or a little curio or something that's not from one of my clients or not related to one of my clients' cases. Employment litigation, by and large, is probably, at least in my humble opinion, one of the most difficult areas of the law.
I agree. I mean, not very many people want to mess with it because it is so difficult, labor intensive, and you got to fight all the way through.
You do. It's very complicated. I think the notion in employment litigation, some people kind of have the feeling that, well, if I file suit, then they'll recognize they're wrong and they'll fix it, and that simply doesn't happen. I have litigated cases all the way to the United States Supreme Court.
And let's point out to the folks that that's a rarity. Not many lawyers actually argue in front of the United States Supreme Court, and you have.
Right, well, that's true. I mean, not any of them necessarily even go up on writs
That's
and
right.
things of that nature. I think I've been to the United States Fifth Circuit more times than I can recall, the Fourth Circuit out of North Carolina, and some things like that. So I very much have been blessed to have, I think, fallen in it at the right time and to be able to learn it from the very
its
baby steps.
inception,
Absolutely.
yeah.
And fortunate to have litigated some issues that made an impact nationally. One of the cases that I am extremely proud of was an Americans with Disabilities Act case. And we litigated that, originally lost it in the trial court, appealed it to the U.S. Fifth Circuit, and they issued an opinion which kind of is the gold standard for what employer responsibilities are in the area of disability litigation.
Excellent.
Yeah, so it's a wonderful challenge.
Well, let's give the folks kind of a big, broad overview, like we're sitting in a helicopter looking down, about how this works. Because as I understand it, you have two sets of laws that can be involved, state law or federal law, or both.
Correct.
Explain how that works.
Well, I don't want to be too complicated, but you basically have the state statutes, which to a large extent mirror what the federal government has enacted over the years, starting in 1964. And that's how long a lot of the legislation dates back. Our state statutes protect against discrimination on the basis of sex, race, national origin, disability status, pregnancy status,
Age.
religion, age, in basically one statute.
Okay.
The federal statutes do the same thing, but in about 7 different
Bunch
statutes.
of those, right?
Correct. And they apply in different contexts. If you are what's called a state actor, you're a town or you're a school board or you're the state of Louisiana actor under some circumstances.
Or maybe you could say an employer, the employer.
The employer and some individual liability. You have to kind of fall within certain aspects of the civil rights statutes. There are requirements in both laws, and a lot of people don't realize this, that for example, if you do not have 15 or more employees, you can't be held liable for what we would consider to be sexual harassment. It was originally enacted, I think, to protect small employers. And as a result, a lot of folks who have been victimized have really no recourse left to them.
Interesting. And let's talk about the reasoning or purpose for the laws, the discrimination laws in the first place. What is it?
Well, essentially the way it all started was, if you reach back really far, you have to look at the 14th Amendment, which came in the 1800s. And that was really the first, I guess, national say-so that we will not tolerate illegal discrimination against people who are in the, quote, minority. At that time, it was primarily driven by the notion that post-Civil War Reconstruction, we need to ensure that we are treating equally African Americans at that time, who were considered what the law calls a discrete and insular minority. From the enactment of the 14th Amendment, ratified throughout the states, we end up in 1964, which, as you all know, was the advent of the civil rights movement in the United States.
Which is more specific, I guess, kind of laser beam type of legislation instead of this broad principle.
Right.
Okay.
It's a lot broader than the traditional notions of equality as you and I would think about them. So in 1964, with the civil rights movement, Congress enacted originally what's called Title VII, along with some other things. There were the 1983 claims, and I know this is a little complicated, but those were originally designed to essentially remedy what we would consider to be police brutality instances. They also enacted 1985, which is the Anti-Conspiracy Act, originally called the Ku Klux Klan Act for obvious reasons. And so from that point forward, the law has really kind of evolved to where we are today.
Well, let's continue this discussion on the next segment. This is Locke Meredith and Legal Lines, and Jill Kraft will be right back.
Want to learn the secret to big savings on TV, internet, and phone? It's bundling your services with Cox. When you bundle with Cox, you get digital cable, high-speed internet with Power Boost, and telephone, all for one low monthly price. That's 3 fantastic services at one low price that will make you smile. The secret is out. The more you bundle, the more you save. So get a whole lot and save a whole lot when you bundle with Cox. some people still don't have on-demand from Cox.
Impersonators.
Who you calling an impersonator, pal?
No. You insulted him a little bit.
A little bit.
A little bit.
Is there a reason you all aren't using on-demand from Cox? Because I thought you guys would love access to thousands of movies and shows.
Stars don't like to watch.
They're all movies. It's tacky.
Did I mention a lot of it's free?
Free is hot.
Boom.
On-demand from Cox. Perfect for almost everyone.
Welcome back to Legal Lines. I'm Locke Meredith. I'm very pleased to have on the show today Jill Kraft. She's an attorney who specializes in discrimination litigation. Jill, again, thanks.
You're welcome.
Let's talk about, well, you were talking about on the first segment that the purpose of the laws were to protect folks that society had decided needed additional protection.
Absolutely, and it came as a result of the history in this country. And again, remember, all of this kind of initially started post the Civil War.
So race was the issue.
Race was the issue.
And so it dealt with that initially.
Right, and then over time, when the Civil Rights Movement began, and a lot of people think of it only in terms of the 1960s, but really its genesis was in the 1920s. And you had the suffragette movement.
Oh, okay.
With women being
voters.
able to vote, and so hopefully people realize women were the last folks to be able to vote in this country.
Right.
And so then you kind of follow its little history up to the enactment of Title VII, which was specifically designed to protect women, well, it says sex, gender, minorities in terms of race, religion, and national origin. And so from Title VII came a whole bunch of cases and decisions taking the terms, for example, sex out of Title VII, and now we understand that to include men are protected classes, male on male or female on male sexual harassment, correct. The term race and national origin, while they were distinct in the 1960s, have become over time almost kind of fused in the sense that, for example, a person who is of Mexican-American heritage is considered to have both a national origin and a race claim at the same time, right?
Interesting.
So it's really kind of evolved.
Does that benefit you if you have two separate bases to allege discrimination?
It does and it doesn't. I think it does from the standpoint that when you have two different pigeonholes that you can put your claim into, the language of the statutes in some sense are different, and in a lot of sense it's the same. It hurts you from the standpoint that it can sometimes be confusing to a jury when you're trying to talk about, well, this is the civil rights claim, and this is
So it's like you got two bullets, you're not sure you want to shoot both of them.
Correct.
Okay.
Or if you want to, take a shotgun and shoot them all.
Gotcha. Explain to the folks how it has now evolved to deal with pregnancy
Correct.
and age.
We have the Age Discrimination and Employment Act is kind of one of what I consider to be the newer kids on the block. It's not actually as new as some of the other acts, but it was decided in Congress that folks who became over the age of 40 and 50 were disadvantaged, meaning if you look at history in the 1980s, you'll remember that there were these massive layoffs
Firing
going
off all
on.
the old folks.
Correct.
Who I'm part of now.
Well, me too. And so, and then you had the justifications being higher insurance premiums, they're more expensive workers, so to speak, they have these large retirements that they've built up. And so Congress reacted really by doing the right thing, saying that you cannot take action against someone on account of their age.
Solely based on age.
Right, and it's not solely, it's on account of. Age can be a factor. If it is a factor, it is illegal.
Interesting.
Now, the pregnancy aspect of it, again, was a reaction, I think, to changes in society. And I guess that's a common theme when you look at the employment discrimination laws. That being when women started re-entering the workforce en masse in the 1960s and 70s, child care or illness of children or taking care of parents or pregnancy became a very big issue. Hence, what came out of that was what's called the Family and Medical Leave Act. That has evolved to protect everybody, not just pregnant women or sick children, but anyone who either themselves or a close family member has a serious health condition.
So it's not related strictly to gender at all?
No, it is completely gender neutral. Now in Louisiana, we have a companion, and this is why it gets a little confusing. We have actually a pregnancy discrimination component in our laws. which says that you get up to 6 weeks leave, unpaid, or if you can use your leave, great, for pregnancy or pregnancy-related medical conditions. In the Federal Act, it affords you up to 12 weeks unpaid leave as long as you've worked a year or 1,250 hours and you have 50 or more employees. I think that's right, 50 more in a 75-mile radius. So it covers everybody. Our state statute does not, but the federal statute is kind of the umbrella protection.
And then, as I understand it, a protected class in addition to those is now folks with disability.
Correct.
And that's,
as I alluded to earlier, the Americans with Disabilities Act is a 1992 creation from Congress, and it was phased in over time in 2 distinct periods, 2 years apart, depending on the size of the employer, as I alluded to earlier. A lot of folks who work for employers who have less than 15 folks on the books, or in some instances 25 on the books, or in some instances 50 on the books, are not protected as a matter of law.
I'm curious, is that a common hurdle that someone has to jump really in prosecuting any of these types of claims?
It is.
The number of employees?
It is, and it breaks my heart a lot because people will contact my office and have really heart-wrenching stories about what's happened to them. And of course, we try to ask them how many folks work with you, how many are on payroll, how many are full-time, that kind of thing. And when you see a situation that is just awful, but it's an employer that has 8 employees, there is really not a lot you can do.
Really? Nothing at all?
Nothing. Now, it used to be in our state statutes 8 was the cutoff, which is why I used it, and we've since raised it depending on what type of discrimination you're talking about, but generally speaking it's 15 or more.
All right, so let's say I've been discriminated against based on any one of these factors, and I come to see you. What happens? What do you do? Take me through the steps.
Well, there are a couple of things you have to do depending on whether or not you're falling under state law or federal law, and in my preference, I try to put both of them together. Under our state discrimination laws, you are required to send a notice to your employer that says, this is what's happened to me, or this is the basis of my claim, and let's try to work it out. You have 30 days to do that before you file suit. Under the federal statute, generally speaking, and some of them have preconditions, some of them do not, but speaking in terms of the ones that do, you are required to file a charge of discrimination with the Equal Employment Opportunity Commission,
which is the EEOC
which we all hear about, within 300 days of the last act of discrimination. And
so 2 different time frames within which you have to act depending on what law.
Absolutely. And the best advice I can give to people is, if you believe you've been discriminated against, do something. Absolutely. Get off the stick and go and do something. The EEOC, you can call by phone. They have a website with all their forms you can fill out and file. You can actually go in person. They're off Poydras Street in New Orleans, and file it yourself. You do not need a lawyer to protect your rights, at least initially. It gets a little bit more complicated from that point forward, but strictly speaking, move and move quick.
The notice that has to be given to the employer, is that something that has to be done in writing, or is just verbally going in and meeting with the employer, or do you just always file a complaint with the EEOC and that counts no matter what?
Well, it's sort of 3 different questions. Number one, as it's currently interpreted, I think it's in some sort of written form.
Okay.
So
that's, going in and saying so-and-so touched me, make him stop, may not work.
That doesn't necessarily work to trigger your rights in terms of pursuing a lawsuit, but you certainly do need to let somebody know that this is going on in your workplace.
Okay. Well, let's continue this discussion on the last segment. This is Locke Meredith and Legal Lines, and Jill Kraft will be right back.
Did you know that high-def programming from Cox is free? That's right. Cox gives you a ton of HD channels for no additional cost. Your favorite HD channels, your local channels in HD, and even more HD choices with On Demand, and more are being added every day. So get a whole lot more HD for a whole lot less with Cox Digital Cable.
Welcome back to Legal Lines. I'm Locke Meredith, and again, pleased to have on the show today Jill Kraft. She is an attorney who specializes in discrimination litigation. Jill, thanks again.
You're welcome.
We were talking about that if you're discriminated against, number one thing you need to do first is provide the employer notice.
Before you file suit.
Right.
It's always good advice. If you're in that situation, you really need to tell somebody. Employers have gotten a lot better these days than certainly I saw almost 20 years ago in terms of having postings in the workplace, human resource departments, tell a supervisor, things of that nature. But if you have a claim and you've done those things and nothing's happened or it's gotten worse or you've been terminated and things of those nature.
Which would be a retaliation type of
litigation. Which would be a retaliation claim, whole different ballgame. From that point forward, before you file suit under a state statute, you do need to send some sort of written correspondence. You asked in the last segment about the EEOC charge.
Right.
If you file a charge with the EEOC, they are required to notify your employer within 10 days, theoretically, of you filing that charge. That written notification or your filing with the EEOC satisfies the state requirements as well.
You said in theory they're supposed to provide the notice in 10 days. I guess it doesn't happen regularly?
Well, the New Orleans District Office does the best that it can, but you have to understand that the level of claims and the number of claims that have been funneled through the EEOC in the last, almost 20 years has exploded, literally.
Really?
And so, and I can't remember what the average intake numbers are in New Orleans, but it's several thousand a year. And a lot of people, file with the EEOC thinking, well, I've been wrongfully terminated. They may have been wrongfully terminated, but the question for the purposes of filing a lawsuit is, have you been illegally terminated on account of one of the factors we've talked about already?
So are you saying maybe they shouldn't count on an EEOC notice going out as being their written notification?
Right,
maybe
I don't think
both?
Yeah, I think the safer practice is really to do both.
Okay.
And do both initially for a whole host of reasons.
All right, let's say that's happened.
Yes.
Notices have gone out. What happens next?
The EEOC has a 6-month period within which it should investigate your charge of discrimination. In reality, because there are so many victims and so few resources, that does not happen. They simply can't do
What's
it.
the typical turnover?
If you let a charge sit with the EEOC, it could sit there for years.
Really?
But after the first 6-month period, which we call a preemptive period, you have the right to request what's called a notice of right to sue. Once you get that little piece of paper, it's going to tell you you have 90 days to file suit in either federal or state court. And if you file on day 91, you're out.
God, that seems crazy that you're required to do something that you know is not going to result in investigation timely, and all the evidence goes stale for 6 months or more.
Well,
Good gosh, how do you deal with that?
I really don't want to get on my political soapbox about how federal bureaucracies develop, and certainly
Bottom line is you just got to, that's the playing field you're on, and that's what you got to deal with.
Although, my little plug would be, as much good as the EEOC can do and has done certainly over the years, I think that the filing requirements should not be mandatory. I think they should be discretionary, and let folks go into court and do what they need to do.
All right, so the 6 months goes by, probably they haven't done what they need to do, so now you can file suit on behalf of your client who came in and hired you.
Absolutely.
So how does that go?
Well, employment litigation, and I can't stress this enough, is probably, as we said earlier, extraordinarily difficult, and it's extremely emotional for everybody involved. And I don't want to just speak in terms of my clients, the victims,
Right.
but also the employers. And the last thing you want to be accused of as a supervisor for, ABC Corporation is discriminating against somebody because they're of a different faith. So it tends to, from the very beginning, be a very polarizing experience.
Very adversarial. huh?
Absolutely adversarial. And part of my job, as I see it, over representing the plaintiffs, is to try to get my clients to a place where they become a little bit more at peace and not so angry and devastated about what's happened to them. The other part of employment litigation that I hope comes out of it is, at the end, everybody learns a little something. That employers, to the extent that they've had these problems, do something to address it. And like I tell every employer who asks me, for advice and things of that nature, the easiest way to not get sued for employment discrimination is just don't discriminate.
Mm-hmm.
And if somebody comes to you as a supervisor or HR or a coworker, or you see it going on, tell somebody. Absolutely open your mouth and tell somebody.
So the litigation itself, is it a typical type of civil litigation where discovery is exchanged, meaning questions go back and forth, the production of documents, and you take the depositions and all of that?
It is and it isn't. The depositions, by definition, are very, very long, arduous, and fact-intensive. The average time to take one of my clients' depositions, don't ask me why, except that thankfully we have a limit now. A lot of my clients have been deposed for 7 hours.
You got to be kidding
I'm
me.
not kidding. Before the federal rules were changed, I had one client they deposed for 2.5 days. The other thing that makes employment litigation different is the fact that most employment cases are decided up or down on motions to have the case dismissed. And typically, if you overcome what's called a motion for summary judgment, then your trial setting is going to happen after that point in time. And
So what is your burden of proof?
The burden of proof is the same as any civil litigation, preponderance of the evidence. How it works, depending on the type of claim, is a little bit complicated, but the bottom line is, depending on the type of case, is burden starts with my client saying, this is what happened to me. If it's a termination case, the employer has an opportunity to say, here are legitimate non-discriminatory or non-retaliatory reasons for doing what we did to Aunt Sue. Then the burden shifts back to my client to articulate why it's wrong, false, or otherwise illegal.
Bench and or jury trial?
I prefer juries. And I think the reason is because if you talk about discrimination, what you're talking about is the simple notion of just treating people fairly and equally. And everybody understands that. Similarly, everyone who's worked for somebody else understands the notion of having, I hate to say it, a bad boss, a hard boss, or things of that nature. And it really is, in my line of work, about something greater than my clients or the lawyers or the judge. It really is about the 14th Amendment and what this country was founded upon, that being the notion that everyone is entitled to be treated equally, period.
What are the categories of damages?
In general terms, you can recover damages to compensate you, compensatory damages.
So I was fired on this date. If I'd been employed, I would have earned this amount of money, so pay me that sum?
No. Emotional distress, humiliation, embarrassment. You also can recover, obviously, lost pay and benefits. And then, most significantly, in most of the cases, you can recover punitive damages, which are designed to punish the employer and to deter that conduct from occurring in the future.
Now, that would be primarily in the federal system, or is that in our state law also?
It's only in the federal law.
Right, that's what I was thinking.
Right.
And I assume that it's for those particularly bad circumstances where you could get sizable punitive damages.
I believe so, yes.
You have, right?
Yes.
Okay. So bottom line is, what is your advice to folks if this is taking place?
Document it. Keep notes of what's
How do you
happening.
document it?
Make notes. Keep track.
This day, like a journal,
Absolutely.
diary.
And report it. Open your mouth and report it.
And when do you also create witnesses that you're going to use at trial? In other words, you tell so-and-so, hey, this is what's happening to me?
This is what's happening to me, right? And you've reported it to the employer, and it assists you in terms of the long-range litigation. Did they act right?
Excellent. Jill, thank you so much
You're
for
more
being
than
on the
welcome.
show.
Thank
Appreciate
you.
it. This is Locke Meredith with Legal Lines and Jill Kraft. Thank you for being with us today.